Your Majesties, Your Royal Highnesses, Your Excellencies, Heads of States, Africans, including the African diaspora, countrymen and women, sons and daughters of the soil which we all call home, black and white together. This is the last Heritage Day we live and strive for freedom in South Africa, our land, and it is the first Heritage Day we live and enjoy freedom in the universe, our home. For it is only a slave that lives and struggles for freedom in their land. The person who maintains that all must live and struggle or strive for freedom in South Africa, our land, is Cyril Ramaphosa, assisted by judicial officers as envisaged at Section 4 of the Constitution. A person who maintains that all must live and enjoy freedom in the universe, our home, is Lieutenant Commander Sylvester Volane Madala Mangolele, as obligated in terms of Section 4 of the Constitution. The Republic of South Africa shall immediately cease to be a slave nation in the dark, and shall rise to the light above the height of all our fathers since the days of slavery, or to fall into darkness with all that is left with our kin. To live or strive for freedom, or to live and enjoy freedom. Freedom is the right in the Bill of Rights, which is a cornerstone of democracy in South Africa, and it enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. To promote the achievement of equality, legislative and other measures designed to protect or to advance persons or categories of persons disadvantaged by unfair discrimination have been taken to advance human rights and freedoms, non-racism, non-sexism, supremacy of the Constitution and the rule of law, a national common voters roll, regular elections, and a multi-party system of a democratic government to ensure accountability, responsiveness, and openness, as that is which all Defence Act personnel in the People's Navy carry in their shoulders as obligated in terms of Section 1 of the Constitution. It is South Africa that I carry on my shoulders. Matamela Cyril Ramaphosa, you are removed from office on the grounds of a serious violation of the Constitution or the law, serious misconduct or inability to perform the functions of office by force number 99004046 MC Lieutenant Commander Sylvester Volane Madala Mangolele, who is a citizen, a national security, a peace officer, or a justice of peace, and acts in terms of Section 20 of the Defence Act. Matamela Cyril Ramaphosa, your removal from office by a force number is not a coup d'etat. It is service and defense of my country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. As I have pledged, and Parliament or the National Assembly shall, in terms of Section 50 of the Constitution, dissolve before expiry of its terms as a result of a vacancy in the office of the President. The Defence Force is not a Mickey Mouse constitutional obligation, and the term discipline appears once in the entire text of the Constitution at Section 200 for the Defence Force to be structured and managed as a disciplined military force whose primary object is to defend and protect the Republic, its territorial integrity, and its people in accordance with the Constitution and the principles of international law regulating the use of force. I am duty-bound to discipline all people to prevent crime, maintain law and order, or preserve internal security of the Republic as obligated in terms of Section 20 of the Defence Act. Since Chief Human Resource of the South African National Defence Force, Lieutenant General Malungiso Sichongaye, is unable to prevent crime of my subordinates and all people of the People's Navy living and struggling or striving for freedom in South Africa, our land, and not complying with the obligations imposed in terms of Section 9(2) of the Constitution. Ignorantia juris non exusat. Ignorantia legis neminem exusat. Neminem sestur ignorantia legem. Ignorance of the law is not an excuse. Ignorance of the law excuses no one. No one is considered to be ignorant of the law. The defense force is the last line of defense when all organs of state fail to uphold, defend, and respect the Constitution as the supreme law of the Republic. It is the honest truth that what happened in Burkina Faso is that which I am doing in our country with the resolve of South Africans, as individuals and as a nation, to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life as obligated in terms of Section 198 of the Constitution. Delineating governing principles of national security as a resolve to live in peace and harmony precludes any South African citizen from participating in armed conflict, nationally or internationally, except as provided for in terms of the Constitution or national legislation. Our youth is subjected into slavery by people in parliament and the judiciary acting as if they do not know the meaning of the word strive. And it pains me to see the ancestral name of our mother and father being continuously enslaved by intelligent people who do know the meaning of the word strive to mean struggle, attempt, try hard, or exert strenuous effort for freedom in South Africa, our land. A peace officer may without warrant arrest any person who commits or attempt to commit any offense in his presence or who willfully obstructs him in the execution of his duty as obligated in terms of Section 40 of the Criminal Procedure Act. All members of the security services, including Lieutenant General Mkhwanazi, must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic as obligated in terms of Section 1995 of the Constitution. And to this day, Lieutenant General Mkhwanazi did not comply with the law of the land to first arrest the people he is talking about, and then come before a competent court to explain what he is explaining now before another independent and impartial tribunal or forum. The object of the police services are to prevent, combat, and investigate crime, to maintain public order, to protect and secure the inhabitants of the Republic and their property, and to uphold and enforce the law as obligated in terms of Section 2053 of the Constitution. All of us expect to see a police official arresting any person suspected of having committed a crime, then bring him or her to local police station, and then within 48 hours gather or present evidence that will be presented in court when the accused person appears in the court before they are sent to a correctional service facility. Our correctional service facilities are overcrowded by people who are believed to have committed a crime, and none of them have had an opportunity of hearing allegations about them in a commission before they were placed into custody. And some are subject to be on trial for more than 6 or 7 years while in remand, only to be found not guilty for the allegations against them. You see, the persons that are deprived their freedom and detained in jail are equal persons before the law as the persons that Lieutenant General Mkhwanazi is talking about on national media, and are equally entitled to the right and equal protection and benefits of the law as obligated in terms of Section 9 of the Constitution. I thank all people that have assisted me to travel from the Northwest to the Free State province in our country to appear before 3 judges after procuring evidence for trial in terms of Rule 38 of the Uniform Rules of Court to subpoena Cyril Ramaphosa and the ANC Top 7 to appear before court on 18 September 2025. It is fact of history and law that I went to the Free State High Court on 18 September 2025 to sedulously remove you, Matamela Cyril Ramaphosa, from office. And the only reason why you are in office is loss of judicial independence administered by judicial officers who are unfaithful to the Republic of South Africa, declines and neglects the Constitution and the human rights entrenched in it, and refuse to administer justice to all persons alike without fear, favor, or prejudice in accordance with the Constitution and the law. I tell you this fundamental truth because each judge or acting judge stood before the Chief Justice or another judge designated by the Chief Justice and sworn an oath as follows, stating that they will be faithful to the Republic and will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice, and in accordance with the Constitution and the law. So help me God. That is what they have sworn. But the reality is that one is receiving the opposite of such. The reality is that incapacity, gross incompetence, or gross misconduct by judicial officers is that which has kept Cyril Ramaphosa from accountability, openness, and responsiveness as obligated in terms of Section 1 of the Constitution. Justice Madanga knows that I have, as the first applicant, together with all of you, the state as the second applicant, in terms of Constitutional Court case number CCT 141 of 2024, arrested Matamela Cyril Ramaphosa as the first respondent, the Independent Electoral Commission as the second respondent, the Speaker of Parliament as the third respondent, the Chief Justice as the fourth respondent, the Minister of Defense and Military Veterans as the fifth respondent, and Secretary for Defense, Chief of the Navy, Judge President Patudi of the Limpopo High Court, Judge Naudi Odendal of the Limpopo High Court, acting Judge Dean of the Limpopo High Court, in order to prosecute SAPS case number 364/1/2024, registered on 20 January 2024 at Harare Police Station in Khayelitsha near Cape Town for treason, corruption, torture, desertion, cowardice, ill-treating a subordinate, disobeying a lawful command, theft of property or money, entering a false statement on official document, obstructing or interfering with the defense force in the execution of its duties in accordance with the Defense Act or the Constitution, inducing or attempting to induce any member of the defense force to neglect or act in conflict with his or her duty to the defense force, undermining or stifling or seeking to undermine or stifle any procedure for the redress of a grievance, and a contempt of court. However, the quorum of Justices Maya, Kolopan, Madanga, Majid, Matapo, Mhlantla, Rogers, Theron, and Tiko J could not begin to respect, protect, promote, and fulfill that everyone has a right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or, where appropriate, another independent and impartial tribunal or forum. This act of treason on 2nd September 2024 of deciding a matter without hearing it is a willful or gross negligent breach of Article 6 of the Code of Judicial Conduct, obligating a judge to at all times, also in relation to extrajudicial conduct, comply with the law of the land, extending to incapacity giving rise to a judge's inability to perform the functions of judicial office in accordance with the prevailing standards, or gross incompetence or gross misconduct envisaged in Section 177(1)(a) of the Constitution. And the Chief Justice judged herself, instead of acting in terms of Section 47 of the Superior Courts Act, for the President of the Supreme Court of Appeal to preside on the matter as the Chief Justice, who must resolve any dispute by the application of law decided in a fair public hearing before a court, as obligated in terms of Section 34 of the Constitution. Because Cyril Ramaphosa and the ANC top 7 are indeed unable to perform the functions of office, they did not appear in court as subpoenaed, while all people know it to be true that when you are subpoenaed to appear in court, you must appear in court. To add insult to injury, the Judge President and his deputy refused to uphold judicial independence by providing a single judge instead of 3 judges. Excuse me. And the one judge reserved judgment only to continuously keep Cyril Ramaphosa and the ANC top 7 in office, as if all of you cannot see the reality. To this day, the courts have in their power in constitutional matters envisaged. To this day, good people, and it is the truth, to this day, the courts have in their power in constitutional matters envisaged at Section 172 of the Constitution failed to declare that any law or conduct that is inconsistent with the Constitution is invalid, and to the extent of its inconsistency, and failed to make any order that is just and equitable given the terms of record, including a failure to make an order limiting the retrospective effect of a declaration of invalidity and an order suspending the declaration of invalidity for any period and on any condition to allow the competent authority to correct the defect. I sound the call for all to come together, and united we shall stand, and let us live and enjoy freedom in the universe, our home, as obligated in terms of Section 9(2) of the Constitution, obligating that equality includes the full and equal enjoyment of all rights and freedoms. There is no freedom without the security of the person. And Chief Human Resource of the SANDF, Lieutenant General Malungisa Sichongaye, you employ and pay salaries of all security services at Chapter 11 of the Constitution, in order to manage and structure the Defense Force as a disciplined military force that complies with the obligations imposed by the applicable terms at Section 9(2) of the Constitution. You must within 24 hours announce whether you shall, in terms of Section 39, promote the spirit, purport, and the objects of the Bill of Rights for all my subordinates, country and its people and their children, their children's children, to live and enjoy freedom in the universe, our home, or whether they shall continue to live and strive for freedom in South Africa, our land, as proclaimed by Matamela Cyril Ramaphosa. Matamela Cyril Ramaphosa has always sounded the call for all to come together, and united we shall stand. Let us live and strive for freedom in South Africa, our land, which is law or conduct that is inconsistent with the Constitution and the law. All that say Cyril Ramaphosa must continue to be in office simply enslave all of you to live and struggle or strive for freedom in South Africa, our land. And that is why all who supports law or conduct by the incumbent Cyril Ramaphosa to enslave all people in our country shall be removed from office to create a suitable and sustainable environment for our youth to find jobs and to be motivated, inspired, and involved to rebalance and reorganize the Defense Force as a foundation for future growth as mandated by an Act of Parliament in terms of Milestone 2 of the South African Defense Review 2015, leading the country and its people to a trajectory to 2034 as approved by the Honorable Jacob Zuma and his cabinet in view of National Development Plan to 2030. Milestone 1 of the Defense Review is in terms of Section 20 of the Defense Act, herewith successfully executed to remove Matamela Cyril Ramaphosa and others from office as a decline in critical capabilities through immediate directed intervention, as the arrest could not be executed in terms of Section 35 of the Constitution due to judicial officers' incapacity in our country. A gross violation of the principles of cooperative government and intergovernmental relations for all spheres of government and all organs of state within each sphere to be loyal to the Constitution, the Republic, and its people has occurred and or is occurring to an extent that the public administration is not governed by the democratic values and principles enshrined at Section 1951G of the Constitution, obligating that transparency must be fostered by providing the public with timely, accessible, and accurate information. In simple terms, the media and the judiciary are unable to be loyal to the Constitution, the Republic, and its people, and refuse to foster transparency by providing the public with timely, accessible, and accurate information that Cyril Ramaphosa is being removed from office, and everything is kept as secret and away from the public as obligated in terms of the supreme law of the land. For far too long, we have been enslaved by the power of the word of an African child. Our children and their children's children best interests are of paramount importance in every matter concerning them as obligated in terms of Section 28(2) of the Constitution. And I act in terms of Section 1996 of the Constitution and the law at Section 2E of the Defence Act and the Code of Conduct for uniform members of the South African National Defence Force to refuse to obey an obviously illegal order to teach any child to pray to God in national prayer to let us live and strive for freedom in South Africa, our land. I respect, protect, promote, and fulfill that everyone has a right to freedom and security of the person as obligated in terms of Section 12 of the Constitution, and the law at Section 13 of the Military Discipline Code imposes a duty upon me or any member of the Defence Force not to obey or not to desert his or her duty to the Defence Force in any event. Lieutenant General Malungisa Sichongaye, you are commanded to, with immediate effect, stop paying the salary of Matamela Cyril Ramaphosa as the incumbent Commander-in-Chief and start paying Lieutenant Commander Sylvester Vulane Madala Mangolele a salary as a person who uphold, defend, and respect the Constitution as the supreme law of the Republic and promotes the unity of the nation and that which will advance the Republic as envisaged at Section 83 of the Constitution. Save for the most senior judge in the Free State High Court, Judge Van Zyl, in the matter between Maluti Apofung versus King Letsetsa Moloi and others, and Judge Reinders in a matter between King Letsetsa Moloi of Bagoloko Kingdom as the upper house and another versus African National Congress as a lower house and the ANC top 7. Many judicial officers promote a reality in which the Legal Practice Act is the Defence Act. While these are two separate national legislation wherein Section 3(2) of the Defence Act imposes an obligation that in the event of any inconsistency between the Defence Act and any other legislation in force at the commencement of the Defence Act other than the Constitution, the Defence Act prevails. I am pleased and blessed to have had Advocate Ngobeni in one matter which we won with cost at scale B as the respondent's representatives against the applicant as the municipality that was represented by Senior Counsel Francois Bottas on 8 May 2025. And the successful judgment was handed down on 10 June 2025 in the Free State High Court. Also, in one other matter in which I represent the applicants and Advocate Ngobeni represents the respondents only to mislead the court on 18 September 2025 that I have no right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent or impartial tribunal or forum as obligated in terms of Section 34 of the Constitution. And also opposed that Henry William MacArthur be a friend of the court to ensure the independence of the court to respect, protect, promote, and fulfill the rights in the Bill of Rights at Section 34 of the Constitution. A matter whose judgment is held in reserve since 18 September 2025 to keep Ramaphosa still in office as you have been misled. The point is that intentionally missed is that the Legal Practice Act is subject to the Defence Act, and not the other way around. Unless the applicable terms at Section 3.2 of the Defence Act ceases to exist, and so does the Defence Force itself. Cessante regione legis, cessat ipsa lex. When reason for a law ceases, so does the law itself. Herbert Broom's text of 1858 on legal maxims lists the phrase under the heading Rules of Logic, stating, reason is the soul of the law, and when the reason of any particular law ceases, so does the law itself. It is treason to promote law or conduct that is inconsistent with the Constitution and as the supreme law of the Republic, for all to live and strive for freedom in South Africa, our land. As I have told you before, it is only a slave that lives and struggles for freedom in their land. I ask all of you to comply with Section 9.2 of the Constitution and understand that Matamela Cyril Ramaphosa has been removed from office. There is a vacancy in the office of the President, and then I shall brief you with the way forward relative to the military command of the Republic. For God has indeed blessed Africa. Papa Oteng.
Hello Mzansi, welcome to Mkosasa Mzansi. If today is your first time visiting this channel, please do the right thing and click the subscribe button, and also don't forget to smash the like button. Yeah, the guys, ngiyakumbula to put low in the video. I think last week where he was saying with him, 18. No, as at last week, yeah, beyakhuluma khona ka Ramaphosa njena ukuthi mhla ka-18 babitiwe lapha eParliament, so that batokhuluma nabo because baneliqala. People saying ukuthi hayibo ngeke base bafike, wathi yena bayofika because lelo langa lokuthi kufanele kuRamaphosa aphume esikhundleni, and we've been waiting, and people are starting to say ukuthi ayi nani ngathi nihlala nikhuluma kuphela nje ukuthi Ramaphosa kufuna step it down because violate ama-rights ala South Africa, but still simbona solo president. Please do comment what you think below down in the comment section. Don't forget to hit the notification bell. I am signing out. Goodbye.